it did participate here, didn't it? Put a brief in
Not
this?
in the UNC case. I don't.
So it was only on
in the
Harvard.
Harvard case.
Right.
And I guess what I would say about that, Justice Sotomayor, is it's true. My predecessor took a different view of the facts. The district court rejected that view, and the First Circuit affirmed the district court's factual findings. So as the case comes to this court, it falls within the court's two-court rule about usually deferring to the concurrent findings of two lower courts.
Now, virtually all of the states that have banned consideration of race in any respect experienced a dramatic drop in enrollment of unrepresented minority students, particularly black students and Native American students, but particularly black students. And even that drop lasted in most of those institutions, if they're not continuing now, at their most prestigious colleges and universities, correct?
That's correct.
So there is a
Respect to
high
Michigan.
price to pay by banning the minor use of race in college admissions, isn't there?
I agree with that, Justice Sotomayor.
And that means that there's a there's lesser number of diverse graduates that enter the pipeline, not just to the government, but to government departments, to the private sector. Many of them require higher education, and so that pipeline is being reduced, correct?
That's correct.
So in the end, our colorblindness, whatever that means, because our society is not colorblind in its effects, that comes at a high cost not only to UNC and to the state and to the nation as a whole, correct?
That is correct. And I think, again, to return to the example of the military, it's the pipeline question is critically important there because the military has a closed personnel system. And what that means is we don't do lateral hiring. And the individuals who are entering college today, the individuals who are participating in ROTC programs today at civilian institutions or who are admitted to the service academies today are the closed universe of individuals who are going to be eligible for leadership in the military in 20 and 30 years' time.
So if we overrule Bakke, Grutter, and Fisher, the diversity admissions programs across the nation, based on those cases, will have to be reformulated in every instance. We will have to work affecting countless existing programs.
Correct.
We're reducing underrepresented minorities.
Yes.
We are depriving others who are not there of the benefits of diversity.
Yes.
And we're doing all this because race is one factor among many that is never solely determinative, correct?
Yes.
Seems like a lot to ask.
But I do want to emphasize to the questions about whether this will end and the questions that Justice Barrett and Justice Kavanaugh, you were asking about Grutter's 25-year context, that I do think that eventually there is an endpoint in sight, and it comes directly from the court's narrow tailoring doctrine in this area. I think that diversity in higher education is absolutely a compelling interest, and it will remain so. That is constant. That's not going to change. But our society is going to change in ways that enable more and more universities and colleges to try to achieve the benefits of educational diversity without having to take race explicitly into account.
Sorry, but many of the civil rights statutes and some of the laws pertaining thereto were directed to being equal to whites. So there was consciousness of race in those statutes.
I think not in a relevant sense. Those statutes, this court said in the Jam case in 2019 that exact language is colorblind, that whites, you have to have the same rights as whites, which means everyone is equal. Now, they used race-based language, but what they did was they banned racial discrimination.
So
That's
what
not
do
race
we
consciousness.
do about all the legislation that was passed that gave benefits not just to former slaves, but to free blacks? That was still remedial in your mind? Because there was inequality, correct?
I believe it was. It was in response to an entire system that had been built up of de jure discrimination. I think those were remedial statutes as well. And
so even if we have de jure discrimination now or segregation now, Congress can't look at that? Because we certainly have de jure segregation. The races are treated very differently in our society in terms of their access to opportunity.
I believe that the remedial exception is still good law. It was one of the two things that justifies the use of race in education that this court identified in parents involved. However, Harvard has not made that argument. It has no factual record that you would need to support that argument. It does not justify its use of race based on its own prior discrimination against blacks and Hispanics.
Are you aware of de jure segregation today?
I am not. I'm aware that that racial preferences on college campuses, in our view, have increased racial consciousness, and so there's some of this is happening on campus, but it's not de jure.
It's not clear that there's segregation between there are large swaths of the country with residential segregation. There are large numbers of schools in our country that have people of just one race. There are schools, districts that have only kids of one race and not multiple race or not white people. De jure to me means places are segregated. The causes may be different, but places are segregated in our country.
Absolutely. I think the top 10% program in Fisher, which really got a bad rap in Fisher too, but was meant, solutions like that are meant to account for residential segregation in a race-neutral way.
Yeah, the problem is that they don't. That's what the district court found.
My memory of Fisher 2 was that the top 10% program was extremely successful at increasing the enrollment of underrepresented minorities at Texas. There are other solutions. We have a very sophisticated race-neutral alternative in this case that takes into account socioeconomic status and forces Harvard to eliminate its preferences for the largely white legacies. And that is another way. I mean, our numbers, the number of Asians would increase on campus, the number of Hispanics would increase on campus, the overall number of underrepresented minorities would increase on campus.
Blacks wouldn't increase.
Black representation would be 10%, which is higher than it is in the state of Massachusetts, and that number is quite low. Our expert testified that if Harvard was only willing to consider wealth instead of income, that number would be quite a bit better, because the main disparities we see on the basis of race today is not on parental income, but on generational wealth.
Get an automatic plus for checking a box?
No.
That's the whole point, isn't it? That checking the box is not what gets you a point.
Right, right. And I think, I mean, one helpful illustration of this point, for, Your Honor, is so SFFA's own expert, their own deciles analysis finds that among the most academically qualified students, Asian Americans and white applicants actually have a higher acceptance rate than black students. This is their own expert evidence, and this is discussed at PADAP 78. As the district court commented, that is a particularly strange result if their characterizations of our admissions process are accurate.
Mr. Park, on this issue of when this will end, 9 states have chosen to rely just on race neutral, completely race neutral, with race being not even a small factor anywhere. Not all of them have been as a result of the people voting. It's been the systems themselves choosing this. Isn't that the case in Florida?
That's my understanding. In Florida, it's an executive order, and there are many states where it's institution by institution. So Georgia, for example, is...
Now, even your adversary said he didn't see the 25 years as a set deadline. It was an expectation. What we know, we have 9 states who have tried it, and in each of them, as I mentioned earlier, white admissions have either remained the same or increased, and clearly, in some institutions, the numbers for underrepresented groups has fallen dramatically, correct?
That's my understanding, yes.
All right. What we also know in those 20-odd years is that racial disparities has grown dramatically as well. Segregation has grown. The disparity between incomes has grown. And so has the effects of these things in terms of the resources that underrepresented groups receive, correct?
I believe that that matches much my understanding, yes.
And I understood that the district court found that UNC, on a continuing basis, reassesses its race-neutral factors and is constantly monitoring whether they've reached some form of representation adequate for their system regularly, correct?
Yes, yes. And
that was your point, which is we can't tell you it's going to end in 2029 or 2030, but we're not just assuming it will continue, we're looking at it regularly to see when it ends, correct?
Exactly, Your Honor. And there really is a quite extensive infrastructure that the university has established to continually monitor our progress on this score. I mean, a whole range of committees, but the committees actually include some of the world's leading experts on doing these kinds of qualitative assessments. And so it's something that we are continually pursuing. And right now, there are many other projects ongoing for us to try to reach the day where we can find a viable race-neutral alternative.
Thank you, Counsel.